Perfect. So, yeah, as Alison said, we've been trading now for 20 years, really exciting, and we kind of periodically do these sort of webinars for our clients and retained pool of businesses that we service. And this one's quite a big one for us because we've got quite a few employment law changes that are up and coming that will actually impact a fair few people. Sorry, someone's just joined and their microphone's on. Would everyone just mind? I don't know who I just let in. There we go. Thank you. Someone, uh, perfect. So if we kick off with some of the major changes that we're going to be talking about today. So this is essentially what's on the employment law horizon for the foreseeable for this year at least. We have paternity leave, COVID annual leave carryover. We've got holiday accrual and holiday pay, minimum wage increases, skilled worker visas, unpaid carers leave, redundancy protection, and flexible working. Everything that you see in those first two we'll be covering today. And then as we follow through into the summer months, you'll see there's a couple of other changes to legislation that are on the horizon. And again, we will just update you periodically when those come through. It might be another webinar that we do. And lastly, there's a few pieces of legislation that are still being debated about, and we will just keep a close eye on those. And if we need to, keep everybody updated. But as we said today, we have got quite a lot to cover in a short space of time. So it will be very much highlights, whistle-stop tour of what these are and what these mean. And then, as always, we can reach out with further details if you feel that a particular change is going to really impact your business. So there we've got the changes. We've also we've got the dates there. So a couple of most of them are coming in from April, start of April. So imminently with some actions that are needed. Okay, so the first one that we're coming on to is change to statutory paternity leave. So as it stands at the moment, statutory paternity is 2 weeks leave. And the new legislation around the paternity leave amendments regulation 2024 will allow parents and fathers to have greater flexibility to take their leave with their baby as in when suits them and their partner. So what does this mean for your employees? This means that the parents or fathers of the baby will be able to split the 2 weeks statutory paternity leave into 2 separate week blocks at any 12-month point from the point of birth or placement, should it be an adoption. They also only need to now be able to only give you 28 days notice of taking that leave. And then if they wanted to change that or remove a block and move it to later on in the year, again, 28 days is really only needed. So it gives a little bit of flexibility, but could also present maybe a few challenges if you're a particularly small team. So what action is needed from you guys when looking at this change? So there is an updated family-friendly policy that will be available in the Dropbox. So for any of our retained clients on this call, this will be uploaded into the template box, and we will email directly to all our clients. I would recommend just providing some training and guidance on all your line managers on how to deal with these requests, and just make sure that you're fully up to speed with what the new policy says. So just make sure that you've got an efficient rollout of the new policy, and then update any of your process maps or your timescales in terms of managing paternity leave. So that again, if you're a particularly small team, it's just a consideration to make. The legislation has come in place, but this is for children that are born or placed after the 6th of April 2024. So whilst this legislation is still being rolled out, it's for any child that's born or placed after the 6th of April. Next change, which is mainly an FYI to most people, hopefully on this call, but just worth just mentioning. The COVID and the pandemic just seems like a million years ago now, but there was a piece of legislation that came out around allowing people to carry over leave because of COVID, and predominantly in the NHS. There was limitations to how people could use their leave just because obviously work demands. But this is just a short kind of slide just to say that actually if that is impacted in your business in any way, or you have had rollover of annual leave because employees were unable to take their leave, that right is now ending as of the end of this month. But I would be really surprised if anybody on this call still sort of has this policy rolling on, but it's like I said, it's just more of an FYI. over to Alison.
So we all know that in 2020, they brought in this lovely piece of legislation that said that anybody who was on variable hours, you had to do this calculation over 52 weeks. And it caused lots of confusion, was very difficult and quite irritating, effectively. And Holly and I spent a lot of time helping clients to work through that. They've now brought in, well, the lovely long title, which I won't do, but new regulation, which means that we simplify holiday for part year workers or irregular hours workers. So particularly relevant for our clients who are in the hospitality industry, where they have perhaps 0 hours people or people who are hourly paid who work all sorts of different hours. And it means that we go back to, do you want to put the slide on? We go back to what we used to use a long time ago, although at the time it was never, although it was used extensively, it was never actually in the legislation. 12.07% is effectively the same as 5.6 weeks in a year for a full-time worker. That's where that comes from. What the new legislation will allow you to do if you have irregular hours worker or somebody who works part years, so term time only people, for example, you will be able to calculate their holiday based on 12.07% of the actual hours they work in a pay period. So it makes it much simpler to work out how much holiday somebody is allowed to accrue. You can, as with normal holiday, allow that to run through. So you would calculate it every month and then allow an accrual. And then when somebody takes holiday, then you pay at the time they take holiday. To be honest, I think certainly for most of our clients, particularly in hospitality, it's a lot easier to say that we'll actually pay it as we go along. Now, I'm sure, like from donkey's years ago, rolled up holiday was something that used to get paid. So rolled up holiday was, at that time, was we will pay you a slightly higher hourly rate, which then includes an allowance for holiday. You still can't do that. And it's a bit confusing that they have used the same name for it. But what they actually mean is that you take the number of hours worked in a month, for example, if that's your pay period, times it by 12.07% to get the number of hours holiday, and then pay that holiday in that payroll period in that month. Just remember, it has to say holiday pay on the payslip, so that it does show that you are paying holiday. But it does mean you can get it out of the way at the time. If somebody then subsequently then wants to take some time off, they don't get paid for it because they've already had their holiday, effectively had their holiday pay. So this will certainly, for those people who want to work in that way, will certainly simplify the whole process. We will be updating our 0 hours worker contracts and our hourly paid contracts where people are working variable hours to allow for that. If you've got people on those sort of contracts, then come back to us in April and then we'll look at updating all of those with you.
So this is applicable from annual leave years that run either from the 1st of April or from January. So what would your advice be, Alison, if someone's holiday is January to December? Technically, you don't need to roll it out till next year, but would you say best practice just to adopt this approach?
It doesn't. The legislation which is currently in place will run until the 31st of December. So unless your holiday year is from the 1st of April 2024 or at some point before the 31st of December, you actually can't change it because the legislation is still on the averaging of the 52 weeks, unfortunately.
And I supposedly the 12.07% in theory comes out very similar to the other, you know, it is a minor change, isn't it? It's just how you calculate it. So
it should do, but it just makes the whole calculation and the whole accrual a lot easier. And if you're paying out month by month, you're not ending up with a big accrual for people to take at any particular time further on in the year. It just makes life a bit, I think it makes life a lot easier.
Yeah.
So but you can't change it until, if you're, and most of our clients are on a January to December holiday year. So you shouldn't really change it till the 1st of January.
1st of January. There's a lot of detail on this slide in particular. We will PDF these and send these out as well. So please, if you're kind of trying to write notes, we'll make sure that you have sight of all of these as in a PDF as well. Okay, from the 1st of April, minimum wage increases. Hopefully this isn't new news, but from the 1st of April, the national minimum wage is increasing. What does that mean in terms of for your employees? It will mean obviously changes to payroll, and anytime you make a contractual change, such as the salary, it will mean new variation letters to be sent and popped on file. So just make sure that you're keeping an audit trail, that you updated them with the effective date that's appropriate with the legislation.
And just to say, for our clients, I've actually just done the template letter, and we're going to email that out later on today or tomorrow to all of our retained clients that they've got that.
Perfect. So on the slide, I won't go through them line by line, but there's the increases on the minimum wage increases, and they're effective from the 1st of April. So if your payroll's 25th of April, you have to obviously backdate it to the 1st to make sure it's from the 1st of the month, not the actual date you run payroll. Important FYI to remember is don't forget to budget for the additional pension and employers' NI contributions if applicable. So again, just take that into consideration, but probably something that may be already on your radar if you've got people that are kind of floating in or around those sort of salary bandings. Another one that's sort of similar to the COVID slide, may not be applicable to many people on here, but just as a point of reference, if anybody on the slide employs an individual on a skills worker visa or are planning to, or it's in the budget in terms of their succession planning, from the 4th of April, the salary requirements for that sort of visa worker will increase quite substantially from 26,200 to 38,700. So yeah, quite a big increase if you've got somebody already on your payroll or you're budgeted for that. So again, just as a similar slide, new variation letters, changes to payroll are in effect, but that one's the 4th of April. So again, we like to keep us on our toes with all these dates. Over to Alison.
So one of the things the government are bringing in is carers leave. So they very generously have said that if you have a dependent who needs who you are the carer for, you can have up to a week unpaid leave in any 12-month period. A week is dependent on obviously how many days you work in a week. So if you only work 3 days a week, it's 3 days in a year, and it is unpaid. They have to apply for it, so they have to tell you, give you notice that they want to take it. And it is in that rolling 12-month period. So how many people will actually take this up? It will be interesting to see. Some employers will enhance that because they will see it as a great benefit for their employees and may pay it or pay half pay or something like that. But the legislation, it is actually unpaid. And it's a day one right, which is another key thing. So you can take on a new employee and you might find that they've only been there a week and then they're saying to you, actually, can I take a couple of days off or can I take a week off because my mum lives with us and she's not well and I've got to look after her. Okay, I'm going to flip to the next one. So it does apply. So it's somebody who has rewind that. So it's for carers who have somebody who has a long-term, effectively, issue. So they would have had something for more than 3 months. So it might be a parent with dementia, for example, or it's anybody who is dependent upon them. So usually living in the same household, but not necessarily. But obviously not lodgers and or anything like that. But it could be a child, it could be an adult, it could be their own parent, and it is somebody with a disability or physical or mental injury which needs more than 3 that they will have had or is expected to have more than 3 months for 3 months. Okay.
Perfect. So from the 6th of April, the Protection for Redundancy, Pregnancy and Family Leave Act 2023 is due to come into force. So that does actually indicate some significant changes to redundancy protection and the process in which you may be managing people that are on maternity leave, adoption leave or shared parental leave, managing their return to the business. So what does that mean for your employee? So essentially this new level of protection, it gives enhanced protection to those that are on on maternity, adoption, or shared parental leave, and it gives them prioritization for redeployment in any other roles within the business over anybody else. And as it stands at the moment, that's up until the point they return from maternity leave. Well, this new legislation now extends, and it's 18 months from the point in which the baby is born, or the week of expected childbirth. So as with all these legislations, they write it very complicated. But essentially, if someone goes off on maternity leave and they take 12 months mat leave, you've then got 6 months post the maternity leave where they would have these enhanced protections. So you do quite often see parents returning from maternity leave or adoption leave, and then unfortunately their roles at risk of redundancy, or there's been a restructure, and at the point when they enter back the business, they are put at risk, and they don't have any automatic redeployment rights, whereas this new protection gives them at least an extra 6 months. The 18 months is set, so for instance, if an employee decides to only take 6 months maternity, they then have 12 months of protection. So the 18 months really does run from either the birth or the week of expected childbirth. I've detailed on the slide different scenarios with regards to adoption leave and shared parental leave. Again, we will share these with you, but there are, particularly for shared parental leave, I don't know whether anybody's had any of those sorts of requests, but that's if someone's had 6 continuous weeks off or more, then that would apply. Adoption leave, again, same sort of concept, but it's at the point in which the placement happens. If I go on to the next slide. So actions that's needed. So an updated redundancy policy will be available on the Dropbox as normal, and we'll make sure that's emailed out with all updated legislation. And again, this is a really interesting one because the actual protections in place from the 6th of April. So a question that Alice and I have been asking for quite a while is actually, okay, well, when, where's the cutoff point? If someone's already pregnant, do they get this? Where does it start and finish? So that what they've come out to say is that if you notify your employer of your pregnancy on or after the 6th of April, then and the maternity leave ends after that date, then this applies. So essentially, anybody that's a little bit savvy, who is maybe a few weeks pregnant, they will probably be holding out until post the 6th of April, I would anticipate, just to be sure that they're clear within these new legislations. But anything else to add on that, Alison? Because you've been on a couple of other webinars about this as well.
Yeah, I think that's the key thing. So it does apply to babies placed or born after the 6th of April, but it will apply from the time the employer is notified. So all the way through the pregnancy while the person is still working. So, but it will apply, like I say, from the time that they tell you. So if they tell you after the 6th of April, it will apply from then. So I think Holly's right. I think anybody who's a bit savvy will be holding out perhaps to tell you. And as long as that doesn't, I mean, we're quite away, we're not that far away now. So because obviously you still have to do the risk assessments and all that sort of thing, and you can't do that until you know somebody's pregnant, they've told you. So.
And I think it's with the redeployment, again, the same pragmatic approach would apply, that if there's alternative roles where the skill set and attributes would be complementary to that role, then you would expect redeployment. But obviously, if it's something that would be potentially beyond their skill set, etc., then there's obviously a commercial view that you can take on that, but it just means that there is those enhanced protection for that additional period of time.
The big question with that is always, are those skills acquirable within a reasonable time frame?
Yeah.
So if it was a redeployment into a different role with a slightly different skill set, but it was something that somebody could probably acquire within 3 to 6 months, then you would be probably challenged if you didn't place them into that role.
Yeah. This is probably one of the trickier ones to manage as the changes come through next month. So yeah, I don't know whether anybody will have any interesting ones, but interesting to hear feedback on that. Alison, over to you for flexible working.
So flexible working, regulators are changing. We've had flexible working for quite a long time now. I think most people are quite used to it. Can you put your mic on silent, please? Thanks. So we're quite used to working with flexible working requests and looking at those, but there are some changes. So the first big change is the fact that they become a day one right. So you may advertise a job for certain days and hours. Somebody could start with you, and the next day, or that day actually, they could put in a flexible working request, and you will still have to follow the statutory process which has been set out. The other big difference is at the moment, so currently 26 weeks before they can apply becomes a day one right. And currently can only make one request in a 12-month period. That will now be 2 requests in a 12-month period. They're also shortening the length of time that you have to consider from 3 months to 2 months, and remembering that that timescale will also have to include an appeal. So the employee will have a right to appeal if you reject their request, and you would have to hear that within that 2-month timescale. Sorry. Why does everybody always want to phone you when you're doing something? So at the moment, when the employee applies for flexible working, we can ask them to explain what they think the impact will be on the team and how their workload could be managed if they're not there to do it themselves. That's no longer a requirement. So you can't ask the employee to justify how their workload will be managed going forward. And you also must consult with them before refusing a flexible working request. Now, that's always been there, and we've certainly always said sit down with the employee and have a chat. And, you know, at that time, then I would suggest you can talk about workload and how that works. But it is very much, you should approach this, and the guidance has always been, start from the position of how do we make this work rather than we can't make this work. And that's always a good starting point, because if you start from that point and you really can't make it work, then that's obviously very genuine, as opposed to, oh, can we twist this to fit that so that we can say no. So once again, we're updating the flexible working policy. You can tell how much work we're having to do this. Thank you very much, HM Government. Flexible working policy is being updated. That will be in the Dropbox, and we will be sending that out to all of our clients. We would suggest that you make all of your managers very aware of the changes. Training and guidance would be really helpful. And if you want, if there's enough appetite for it, we'll run a training session online. And that might, so what you may find is that this is going to spark an influx of requests, but we wait to see, really. And you'll need to review the requests, obviously, as I've said, at a much quicker time span, and respond quickly. Once again, effective from the 6th of April, as most of the changes are.
It's funny with this one, because we said, you know, it'd be bizarre for somebody to go through the recruitment process without mentioning maybe a flexible working need, and then on day one do that. It seems a little bit counterintuitive, but I guess if you've got a candidate who that might be thinking that flexible working request could impact the suitability or the appointment in that role, then I suppose that's when you would maybe be seeing somebody withhold that information until day one. So whilst I initially thought this would probably not be that likely, you know, I can only speak for myself. You know, potentially if I was going for a role that was maybe full-time and I needed childcare, would I potentially hold that back to just secure the role? I think it's on a case-by-case basis, but I do think there will be people out there that feel as though to eliminate any element of, you know, unconscious bias decisions made, or you know, potential discrimination thoughts coming in, they probably would keep that to themselves. But it's an interesting one that, you know, you go through the recruitment process and on day one would want to put another request in. But I suppose you know, stranger things have happened. So
being very similar to people withholding the fact that they're pregnant when they're applying for new jobs.
Yeah, it would be a strategic decision, wouldn't it, rather than anything else?
Yeah, so, you know, you can't, it's exactly the same in terms of discrimination, that you can't discriminate against somebody who is pregnant when in the job process, or going to have children, or of a childbearing age, as the saying goes. And it will be exactly the same with this. You'll just have to deal with it as it comes in. and you certainly must resist the temptation to ask questions around, do you have childcare in place? What responsibility? Because it may not just be about childcare, to be fair. It's about caring responsibilities. It's about wanting to have a different lifestyle sometimes. It is just about actually,
work-life
I don't
balance.
want to work. Yeah. I
Yeah.
don't want to work, full time.
Yeah.
So
Yeah. Perfect. Okay, so I think we have done very good for time, so we will have plenty of time for questions if ever anybody wants to stay on and just ask us anything. But essentially, in today's session, we've covered off quite a lot in terms of high-level changes and what that means for people that use our Dropbox and people that might use those processes on a quite regular basis. In terms of those other items that I talked about that are on the horizon, more information will be coming soon, particularly the one in October 2024. We're looking at launching an in-person practical workshop for those to just support that sexual harassment protection, and that's all around ED&I. Making sure that we've got everything practically in place to support managers, to just be able to evidence as a business case that you have got the right process and audit trail, and resources in the team to minimize any risk that could potentially come up from a sexual harassment claim. So that is quite a major update, and Alison and I were on a conference last year, and actually the expectations or the reasonable considerations that a business will need to make to protect their employees is somewhat doubled. So we just need to make sure that everybody's sort of feeling that they've got that practical assistance. So yeah, watch that space in terms of workshops. Hopefully some of you can join that session, because that'll be a really, really positive one. The last couple of slides, essentially anybody that's on the webinar that's joined us today, that's not already a client, this is just a little slide just to explain what Enlighten HR can offer and the sort of services that we provide. Alison will kill me for putting 24/7 advice, because she says that's on you, not me. But essentially we are your designated HR department that you can outsource, and we don't have limits on how much support we can give in regards to telephone and email advice. We've also got the template bank and documents, which we've mentioned loads during this webinar, so that's always is part of the package. And yeah, we've got a lot of other strategic partners that we can offer businesses referrals into and connections to enhance businesses. So it's not just us, it's a wider network that you'd be gaining in terms of becoming a retained client of ours. And I think that's our details. So anything left for you to say, Alison, before I end the recording, and then we can go to a Q&A?
I don't think so. I think just the most important thing is that we have very personal one-to-one relationships with all of our clients. So it's not like a call center or something like that.
It is just us, isn't it?
Yes, and
just,
Pam.
and Pam.
In there as well at the moment.
Yeah. Perfect. Well, I'm going to stop the recording now, and then we'll go on to any Q&As that feel free to pop them in the chat as well if that would be your preferred method of, if you don't want to kind of go on screen. So anybody that would like to stay on, that's amazing.